Formalities. A private company is exempted from various legal formalities regarding prospectus, statutory meetings, statutory reports, minimum subscription, etc. However, no such exemption is provided to public limited company. Prospectus. It is not required to issue a prospectus. Private company don't need to issue a prospectus. However, for a public company it is obligatory to issue a prospectus or a statement in lieu of prospectus. Next is managerial remuneration. In a private company, there is no restriction on providing any amount of managerial remuneration. However, the maximum managerial remuneration in case of public company can be 11% of the net profits. Next, we have stages in formation of a company. Step 1, promotion. Step 2, incorporation. And step 3, capital subscription. Number 1, promotion. Promotion means discovering a business opportunity and taking appropriate steps to form a company. As per section 2 subsection 69, a promoter means a person who has been named as such in prospectus or is identified by the company in the annual return referred to section 92, or who has control over the affairs of the company directly or indirectly, whether as a shareholder or director or otherwise, in accordance with whose advice, directions and instructions the board of directors of the company is accustomed to act. However, it is provided that nothing in this subclause shall apply to a person who is acting merely in a professional capacity. So what we understand from here is any person or a group of persons who discovers a business opportunity and proceeds to form a company is known as a promoter. The promoter takes necessary steps, completes legal formalities, assembles physical, financial, human resources to form a company. The pioneering promoters in our country include Mukesh and Anil Ambani, Jamsetji and Tata, Ghanshyam Das Birla, etc. So what we understand from here is any group of person or any person who discover a business opportunity and proceeds to form a company is known as a promoter. Promoter takes the necessary steps, completes the legal formalities, assembles the physical and financial resources to form a company. Now, steps in promotion or the functions of a promoter. Number 1, identification of business opportunity or idea. The primary function of a promoter is to identify or conceive a business opportunity. The opportunity may be in respect of producing a new product or service or expansion of existing unit or any other investment potential opportunity. So where there is a business opportunity or idea, such function of a promoter is a promotion function and the first step of promotion function. Next is feasibility studies. In order to determine the feasibility or profitability of a company which a promoter intends to start, the promoter undertakes different feasibility studies like technical, economic and financial feasibility with the help of experts like chartered accountants, cost accountants, architects, engineers, market analysts, etc. So in order to determine the profitability and feasibility of the business which a promoter intends to start, the promoter undertakes different feasibility studies and other economic and financial feasibility techniques are used with the help of experts. First of all, technical feasibility. Sometimes a business idea is favorable but is not possible to implement it. It may be due to non-availability of required technology, raw material or other inputs. The project would remain technically unfeasible until the technology or other inputs are made available from alternative sources. Next is financial feasibility. The study is undertaken to estimate the fund requirements, the identified business idea. If the fund requirement is very large and cannot be arranged easily with available means, the project is to be said to financially unfeasible. Sometimes a project may be technically viable but not financially. So if the capital requirement is very high and it is difficult to arrange such amount of capital with the available means, then such project would be called financially unfeasible. Next is economic feasibility. The study is undertaken to know about the amount of profit expected from the proposed business. A project may be technically and financially viable but not be profitable. So all types of feasibility studies are to be done by the promoter. Next is name approval. After taking a decision to launch a company, the promoter needs to select a name for the company and submit an application to the registrar of companies to the state in which the registered office of the company is to be situated for its approval. So after the idea and feasibility studies have been done, when the decision is taken to launch the company, then the promoter has to select a name of the company and submit an application to the registrar of companies in the state in which the registered office of the company is to be situated. Now, the proposed name may not be similar or should not be similar to the name of the existing company. So, few names are to be provided to the registrar in preferential order so that the registrar would select the most proper and most suitable name. Next is fixing up signatories to memorandum of association. Promoters have to decide the members who will be signing the memorandum of association of the proposed company. Usually, the people signing memorandum are also called the first directors of the company. The written consent of signatories to act as directors and to buy qualification in shares in the company is necessary. In case of a public company, the memorandum must be signed by at least 7 persons, while in the case of private company, minimum 2 signatories are only required. So what we understand from this is the responsibility and the signatories are to be fixed up who will sign the memorandum of association. And now what is the memorandum of association, that we will discuss in the later part of the video. But the promoters will find out 7 persons who agreed to be the signatory of the company, which will also be known as the first directors of the company. Next is appointment of professionals. Promoters appoint certain professionals such as mercantile bankers, auditors, etc. to help them in preparation and submission of necessary documents to the registrar of companies. Next is preparation of necessary documents. The promoter takes up the step to prepare certain legal documents like memorandum of association, article of association, consent of directors, etc., as they have to be submitted to the registrar of companies for getting the company registered. So these are the functions of a promoter. These functions are to be done under the promotion step. As we have seen, the company formation has 3 steps: promotion, incorporation, and capital subscription. So this was all about the promotion step. Next we will see the incorporation step. Incorporation means the registration of a company as a body corporate under the Companies Act 2013 and receiving the certificate of incorporation. Next, let us see what are the steps in incorporation. Following are the main steps for the incorporation of a company. Number 1, application for incorporation. Promoters make an application for the incorporation of the registration of a company to the registrar of companies along with necessary documents. In the step of incorporation, for the incorporation process, first of all you need to make the application to the registrar of companies. Next, filling of necessary documents: memorandum of association, article of association, statement of authorized capital, and consent of proposed directors. These are the main documents that are to be submitted to the registrar of companies. Next, the notice of the exact address of the registered office. Statutory declaration. A statutory declaration stating that all legal requirements of the Companies Act with regard to incorporation have been fulfilled. The declaration can be signed by an advocate of a Supreme Court or a High Court, or a signatory to the Memorandum Association, or a chartered accountant, or a company secretary in whole-time practice in India. Next is payment of fee. Along with filing the above documents, the registration fee has to be deposited. The amount of registration fee varies according to the amount of authorized capital of the company. And at last we have registration. The registrar of company will carefully scrutinize all the documents submitted, and he also check the receipt of the fee deposited. If he is satisfied about the completion of all the legal formalities of registration, he will enter the name of the company in its register and issue a certificate of registration. That is the certificate of incorporation or registration. After entering the name of the company in the registrar, in the register, the registrar issues a certificate of incorporation. It is dated and signed by the registrar of the companies. The moment the certificate is issued, the company comes into existence. The certificate is also termed as the birth certificate of the company. Next is the effect of certificate of incorporation. A company is said to be legally born on the date printed on the certificate of incorporation. It becomes a legal entity with perpetual succession on such date. It can be legally entering into any valid contracts on the above date. The certificate of incorporation is conclusive proof of the legal existence of the company. Next is capital subscription. The first step was promotion, the second step incorporation, now the third step is capital subscription for the formation of a company. A private company can commence its business immediately after certificate of incorporation is raised, but a public company can start business only after it receives the commencement of business certificate. So it needs to raise finance. So what are the steps for raising fund from the public? Number 1, SEBI approval. SEBI stands for Security and Exchange Board of India, which is the capital market regulatory authority in India. It has issued several guidelines for the disclosure of information for investor protection. A company is required to take prior approval from SEBI before inviting funds from the general public. Next is filling a prospectus. A prospectus is to be filled with the registrar of companies. A prospectus is a document inviting deposits or offers from public for the subscription or purchase of shares and debentures of the company. A statement in lieu of prospectus is prepared when public company is confident of raising funds from private sources. In such cases, it will have to fill a statement in lieu of prospectus with the registrar of companies. The prospectus or the statement in lieu of prospectus should make full disclosure of all significant information and must not contain any misleading statement, because on the basis of information given by this document, the investor decide whether to invest or not to invest in the company. So prospectus is a legal document through which invitation is made to the public to provide them to buy shares or debentures of the company. If the public company is confident of raising the funds from private sources, then it may file a statement in lieu of prospectus with the registrar of companies. All the relevant information about the company and its directors and its promoters are to be provided in the prospectus, and there should not be any information which can mislead the decision of the investors to either invest or to not invest in the company. Next is appointment of bankers, brokers and underwriters. The task of raising funds from the public is very difficult. So in order to ease the process, experts in different fields are appointed. Bankers receive and deposit the application money. Brokers distribute the application form and encourage the public to subscribe the shares. Underwriters are appointed by the company if the company is not sure of receiving the minimum subscription of the shares of the public. Underwriters are the person who undertake to buy the shares if these shares are not subscribed by the public. They receive a commission for underwriting the issue. Appointment of underwriters depend upon the direct discretion of the company. So this task of raising funds from public is very difficult. So different type of experts and specialists are hired for this purpose. Next is minimum subscription. To ensure that the company does not have shortage of funds, it is made mandatory that the company must receive the amount of subscription in cash within 120 days from the date of issue. The limit of minimum subscription will be mentioned in prospectus for every issue of shares. If the minimum subscription is not received, then allotment cannot be made and application money must be refunded to the applicants within the next 10 days, that is from 130 days of the date of issue. Application to the stock exchange. It is necessary for the public company to get its share listed or quoted on a stock exchange before it starts selling the securities to the general public. For this, the company has to make an application in at least one stock exchange to get the permission. If the company does not get such permission within 10 weeks from the date of closure of subscription list, then the allotment will become void. Consequently, all money received from the applicants will have to be returned to them within 8 days. Also, before selling the shares to the general public, the company needs to make an application to the stock exchange and get a permission from the stock exchange